Okay, friends, welcome back to another edition of Justice Matters One-on-One. I'm here with my good friend and my former colleague in the prosecution game, Kevin Flynn. As we mentioned in our last video, this is going to be a recurring series. We're still trying to tease out a good name for it, and thank you to the many of you who sent suggestions to my website. We've kind of put together a top 3 or 4 list, and we're going to make a final decision regarding what to call this series. We're 2 prosecutors with a combined 65 years of prosecutorial experience, specifically as federal prosecutors at the D.C. U.S. Attorney's Office. So if you want to send in some more suggestions to my website, you can hit me up at glennkirshner.com. But Kevin, thank you for being back. We have lots to talk about regarding the way U.S. Attorney and former Fox News host Jeanine Pirro has been operating in the courts of Washington, D.C. And spoiler alert, it's not good. But what I want to start with is doing a quick recap of how many times the grand jury has told U.S. Attorney for the District of Columbia, Jeanine Pirro, hell no, we're not going to indict felony charges just because you tell us to. I'm not going to go through the cases chapter and verse, but there are now a total of 7 grand juries who have told Jeanine Pirro and the prosecutors she sends in to the grand jury trying to secure felony indictments of protesters and others. The grand juries have told her no 7 times in a combined 5 separate cases. For starters, that is beyond unprecedented. If over the course of our career we had maybe 1 grand jury say the evidence wasn't quite there and refuse or decline to vote out a felony indictment, that was pretty unusual. 7 times in a matter of just a few weeks is, in my opinion, pretty gross prosecutorial overreach and perhaps even abuse of the grand jury process. So as a result of the grand jury performing its important civic duty as a check against prosecutorial overreach and telling Jeanine Pirro no, Jeanine Pirro had some choice words for the grand jurors in the District of Columbia. So let me throw it to you to talk with our viewers a little bit about how Jeanine Pirro has responded and reacted to being told no by the grand jury.
Thanks for having me, Glenn. It's always a pleasure. Ms. Pirro essentially took the grand juries on and claimed that they were essentially blind or ignorant about the effect of violent crime or crime in general on D.C. And also claimed that they reside in Georgetown and another quote-unquote affluent parts of the city and are therefore not sufficiently concerned about the crime that they themselves are in the city where they themselves reside. And the one thing there are 2 things that 3 things actually that are wrong about that. Number one, it's extremely offensive for a public servant who is serving the public, who is supposed to be serving the public in that job, the public being the city, the residents of D.C., to actually be attacking those same residents for decisions that were made legitimately and were likely the result of bad prosecutorial decisions and a lack of prosecutorial discretion in terms of those cases being brought to the grand jury. And number 2 is there's no indication that that this was the grand juries in this particular case were these particular cases were drawn from any particular part of the city. The fact is that grand juries are a part of the judicial branch. They're not part of the executive branch, which is what the Department of Justice and the U.S. Attorney's offices across the country are. They are a part of the court process, not the executive process. The court selects them, and they are selected from a cross section. They represent a cross section of the city. So there is not one particular location that grand jurors spring from. And so that's number 2. Number 3, which I alluded to earlier, is that grand juries, because they're members of they're part of the judiciary, are not rubber stamps for a prosecutor. But prosecutors, in making decisions as to what cases should go to the grand jury, have an obligation to make sure that only meritorious cases, cases that can be ultimately proved beyond a reasonable doubt to a trial jury, are brought to them. there is a reason why grand juries generally indict cases that are put to them by prosecutors, and that is because prosecutors have already weeded out the cases that should not go to them. In other words, cases that are being brought for purely political reasons, where de minimis injuries have been caused, and cases are being charged as felonies, and grand juries are being asked to indict them as felonies when they actually should be no more than misdemeanors if charged at all. So the comments were extremely offensive. They were inaccurate. They were false. And they were, for all the reasons that I've said, but I'll throw one more in. They really evidence such an ignorance of what a prosecutor's job is. And the fact is that you had trial verdicts that didn't go your way. I had trial verdicts that didn't go my way. But at the end of the day, I didn't walk out, nor did you, and blame the jury system, blame the process. The fact is that I always took it on myself that I and my prosecutorial team and my law enforcement team weren't able to marshal the evidence or argue the case in such a way as to prove it beyond a reasonable doubt, and the jury spoke to me as was appropriate.
And I think we mentioned in the last video we did together, between the two of us, 65 years of prosecutorial experience combined, we had one grand jury no bill the case, refused to indict charges.
And go ahead, that was mine. Okay,
I wasn't going to call you out on that. But you know, and to have Jeanine Pirro publicly berate and demean and disrespect the grand jurors for doing their job is something that I never saw in my career. I suspect you never saw that in your career. We have to respect the grand jury's decision. We have to respect trial jurors' decisions, even if we disagree with them. And it just shows such a fundamental misunderstanding of the role of a United States attorney, never mind a line federal prosecutor in the D.C. U.S. Attorney's Office, that it's offensive, it's demeaning. And, you know, D.C. may be a big city, but it's also a very small town in many ways. And I have a feeling lots of people, including current and future grand jurors, are paying attention to what Jeanine Pirro is saying about them, because she's saying things like, they don't care about crime in D.C. They just live in affluent neighborhoods. Nothing could be further from the truth. Grand jurors, as you mentioned, are drawn from every neighborhood in every quadrant of Washington, D.C., not just Georgetown or where, according to Jeanine Pirro, the affluent people live. It's offensive, it's demeaning, it's disrespectful. But you know what, Kevin? Maybe we should have seen this coming, because there was some reporting in recent days taken from some court filings in a civil defamation suit that was brought by Smartmatic Voting Systems against who? Fox News and Jeanine Pirro. She's a named defendant. And in some of those court filings, here is what we have learned from Fox executives who work closely with Jeanine Pirro and know her best. This is what they said about her. One Fox News executive called her a, quote, reckless maniac. These are some of her supervisors that she worked with at Fox News. Another Fox executive said, quote, I don't trust her to be responsible. A third Fox executive said that she, quote, has a tendency to find random conspiracy theories on weird internet sites. And a Fox corporate board member called a public statement that she made, quote, insane. This is the top prosecutor in Washington, D.C., Donald Trump's United States attorney for the District of Columbia. And that's what the Fox News executives and board members said about Jeanine Pirro, her work, her judgment, her discretion. You know, the people of the District of Columbia deserve so much better. And some of this is now coming home to roost, because we just had a federal magistrate judge named Zia Faruqui, who also happened to be a former colleague of ours. He was a federal prosecutor in D.C. for many years, highly regarded. He has said some things that were just reported out by the Washington Post. So why don't you tell our viewers about what federal magistrate Judge Zia Faruqui has been saying about how Jeanine Pirro has been operating.
Well, he in the course of making observations about the dismissal of a case that had been brought into his courtroom, the magistrate judge referred to it as having been prompted by the most illegal search that he had seen in his life. And this coming from someone who not only had experience as a judge, but long-time experience as a prosecutor. So this is not someone who's making that observation based on 6 months or a year's worth of work in the business. And the circumstances in that case, as they've been reported, are that the police stopped a black male in a grocery store who had a satchel, and according to the police paperwork, that stop was made and the seizure was made because the satchel appeared to be carrying something heavy. Now, you and I both worked many hours in a part of the office called intake, which I won't get into a lot of detail about, but that case would not have lasted 30 seconds on the desk of either one of us before it had been no-papered and gotten rid of before it even went to court. And it's clear from the paperwork, and it's clear from the magistrate judge's comments about it, that this was a pretextual stop based on racial profiling. There really is no other way to put it. And that the fact that that case was brought into court, the fact that a prosecutor was willing to take it through to that stage, shows that there is absolutely no prosecutorial discretion being exercised here in that office. You and I probably spent, I don't even know how many thousands of hours combined we spent in courtrooms, not only as participants, active participants in cases, but also as observers, watching other prosecutors as they went about their business. Both of us were supervisors for many years. I never heard a judge say anything like that in a courtroom about a prosecutor's case in my life. Now, I heard judges say things that were very demeaning, and appropriately so, about the way defense counsel conducted themselves in particular cases. Not very often at all. But for a judge to make a comment like that on the record, and really not only just about the case itself, but implicitly demeaning the integrity of the prosecutors who were involved in bringing that case, and by extension, the integrity of the office, it's really unheard of.
And let me just piggyback on that, because the Fourth Amendment protects us all against unreasonable searches and seizures. Maybe this makes me a con law nerd, but I have a favorite amendment. It is the Fourth Amendment, and it reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." Period. Shall not be violated. As you point out, the court paperwork indicates that, somebody was wearing some kind of a belly pack or holding some kind of a backpack, and it appeared to have a heavy object in it, so the police conducted a search. That violates the prohibition against an unreasonable search and ultimately seizure. And that's why Magistrate Judge Faruqui said, this is the most unconstitutional search I've seen in my career. And I assume that means both as a federal prosecutor and as a federal court magistrate judge. And it is so outrageous that prosecutors would bring a blatantly unconstitutional search into court. And it is the judge who gets to make the decision regarding whether a search was lawful and constitutional or unlawful, unconstitutional. And let me just give our viewers a flavor of a little bit of what else Judge Faruqui said about how Jeanine Pirro and the prosecutors she's sending into federal court to bring these bullshit cases, what Magistrate Judge Faruqui thinks about it. He said, for example, federal judges would continue to push back on implausible, illegal, immoral prosecutions, his words. He also said that the Trump administration's zeal to reduce crime in the nation's capital had touched off a constitutional crisis. He said these officials are, quote, playing cops and robbers on the streets of D.C., and the rule of law is being flushed down the toilet. And one other comment he made, he said that he was beyond outraged that the court was being used and abused to trample defendants' rights. Those are words unlike anything I've ever heard from any judge, and I had the pleasure and the honor and the opportunity to appear before military judges, both trial and appellate court, civilian judges, both federal and local trial court and appellate court, You don't hear judges talk like this. And the reason, I think, in our experience, Kevin, you don't hear judges talk like this is because we don't operate like this. But this is what Jeanine Pirro is doing, and having whatever lawyers she manages to come up with and send into court to spew this nonsense. This is how they are apparently operating. And let me ask you to look into your crystal ball. I mean, what do you see for the future of cases like this? Some of them are being charged as misdemeanor cases when they couldn't get the felony indictments. How do you think these things are going to play out in the future when they are tried as misdemeanor cases?
Oh, I tend to doubt that a lot of these cases will even get to court. I think that somehow or another they will the office will find a way not to subject itself to further embarrassment with respect to these cases. If they do go to court as misdemeanors, the bench in D.C. it leans pro-defendant. It is not a hanging court, and these are going to go before judges who are going to they're going to be human beings, and it's going to be very hard for them to remove from their minds, as they regard these cases, the really dishonorable path that those cases took before they found their way into those courtrooms. But I think not only just with respect to those cases, the thing that worries me the most is that that office is still very special to me as it is to you. I spent the best years of my career by far in that office, and I really held its mission to be sacred. And I worry about what's being done, the really unalterable damage that's being done to that office and its reputation. And I don't worry so much about those misdemeanor cases or other politically motivated prosecutions that the office is going to be trying, this office right now, as opposed to the office that we served in, is going to be taking to court. I worry about cases that that juries are going to look at and judges are going to look at with more skepticism possibly than they should in particular case-by-case instances, and with results that are going to affect negatively cases that really are meritorious, that have real victims, and cases that where evidence should not be suppressed, for example, or defendant should not be found not guilty, but that the office's bad reputation is going to be attached to meritorious cases, and the result in those cases is going to be unjust results are going to be reached in those cases that tilt against the office and against the government in ways that they shouldn't, because it's really very hard. I mean, it meant something to walk into court and to say, as I did, I remember the first time I said it, I remember the last time I said it on my last day in the office, and that was Kevin Flynn for the United States. And that, for the United States, those words meant something. They were powerful. The first time I said them in 1987, they were powerful, and I choked up a bit my last day in the office when I said them for the last time, because that title means something, and that reputation means something, and it has meant something to judges. It means something to juries. You walk into a courtroom, and when you are walking in as a representative of the Department of Justice, a representative of the United States, you should carry with you an aura of respectability, of integrity, and responsibility. And these prosecutors are walking into court, and with every step they take, they're tarnishing the reputation that you and I and thousands of others in that office tried to build for it.
Yeah, and you're exactly right calling it a sacred duty. It was a sacred, we took it so seriously. It was an honor, it was a privilege, it was a weighty responsibility. And let's end with this, because when we talk about an obviously unconstitutional search, which means we as prosecutors would not be permitted to use the evidence that was found when the police unconstitutionally went inside that belly pack or that backpack that arrestee was wearing. When that case came to us, we had an obligation to no paper it, to decline to charge it, not just fumble forward and say, we don't care that it was an unconstitutional search. We're going to run into court with it and see if we can put it past the judge. No, we actually had a constitutional obligation that we took very seriously to make sure we also served as a guardrail, a check against police overreach, missteps, abuse, misconduct, just as the grand jury serves and trial juries serve as a check against prosecutorial overreach, abuse, mistakes, and misconduct. So I couldn't agree with you more that they are tarnishing the reputation of an office that I came to love in my time there, the United States Attorney's Office for the District of Columbia. And let's hope that they can pull up out of this nosedive, somehow, some way. But thanks for jumping on with me today. I will say that both Kevin and I are on Substack. If you want to catch us over on Substack. Also, if you want to hit subscribe to YouTube, it is always free, nothing behind a paywall. But if you subscribe, it does tend to help us along in this mission to continue to get this information out to everybody. So with that, Kevin, thanks for jumping on again, and thanks to all of you for watching another episode of Justice Matters One-on-One.
Thanks, Glenn.